Hi everyone, I am Shannon Laymon-Pecoraro and I am one of the certified elder law attorneys at Hope Law Center. I want to go ahead and apologize for being unable to access the internet on Sunday. Unfortunately, I live out in the country and so I was having some technical difficulties and could not get any messages out. So I guess the positive side of that is you'll have a recording that you can replay back instead. And obviously, if there's any questions, don't hesitate to reach out, and I can maybe try and even schedule like a short phone call session or something through the program so that you do have access to me at another point in time. So first things first, we are what we call an elder law firm. And so with that, we have a lot of experience in public benefits, in particular Medicaid planning. And so with that background knowledge, we are able to also kind of branch out into the special needs arena. And so the vast majority of the special needs planning that comes in through the firm, actually, I work on. And so I work on special needs issues around the country. And that's just kind of been my passion. So that is a little bit about the firm and where we come from. I normally start off some of my presentations with, why I get into the special needs planning business to begin with. And I actually have a cousin who at age 23 was in a motorcycle accident. And before he even hit the ground, his back had actually severed. And so he is technically, by definition, quadriplegic, although he does have some limited mobility in his arms so that he can drive by by his arms instead of driving with foot pedals. And so that kind of personal connection is really what led me down the path of planning for disabilities in general. And so that is my personal connection. That is why I think I'm very passionate about what I do. And I just kind of absorbed it and moved on with it. All right, so the topic or the presentation is going to really focus on what you need to know as a parent for special needs planning. And so first things first, what is special needs planning? It is actually planning to address a long-term disability. That can include both financial planning and personal care planning. And so as we all know, autism in particular has a very broad spectrum. And so one of the first things as a planner that I ask is, I don't need to know necessarily the diagnosis. What I need to know is about your child, because the diagnosis itself isn't going to tell me what the individual child is going to be capable of lifelong. And so we need to make sure that all the financial components are addressed, and then also making sure that any care needs are addressed. It's also important to understand that special needs planning does involve more than trust. To me, one of the most important tools is going to be a power of attorney, if and when a power of attorney can actually be done. It's also going to involve the very involved web of public benefits laws, tax law, and the very particular laws associated with special needs trust. So it's not just, hey, I can draft a special needs trust. It becomes much more of, well, how does that play into food stamps? How does that play into HUD housing? How does that play into SSI or SSDI, depending on, I'll go down that path a little bit more. But so all the benefits that are available and the impact, and then also what's the tax factor in all of this? Because there are, some tax benefits associated with different types of trusts. And then, and I guess there's benefits either way. But depending on the type of trust that is actually drafted, there may be different tax consequences involved. It's also important, and this kind of goes into what I say about, the diagnosis is just the diagnosis. That doesn't tell me about the individual that we need to plan for. And so the practitioner that is getting involved in the planning process really needs to understand the individual themselves. We need to understand what their disability is, what their limitations are, what are they good at, and then ultimately, what are their hopes and dreams, and the family's hope and dreams for the individual. And every family is going to be a little bit different with regards to what their expectations are for their child. And so it's my job to really plan around that to make sure that we can achieve as many of the goals as what we possibly can, understanding that we probably cannot achieve them all. A lot of my clients, these are what their concerns are, just planning for the disability itself. What housing options are going to be available long-term? How are we going to pay for whatever long-term care may be necessary? And so whenever I talk about disability, I may not even just be talking about a disability that begins at birth, but I could be talking about somebody like my cousin Charlie, who at age 23 now needs to figure out, how are we going to pay for the wheelchairs that he needs? How are we going to pay for the attendant care that he needs inside the home? And he is in Pennsylvania, so his benefits are very, very different than what we have here. But it's those types of things that I look at. We're also going to look at what type of assistance may be available to help cover some of this. And then, what tax and estate planning is necessary. And so it may not just be the individual themselves planning that needs to be done, but maybe even their parents or their guardians planning as well, so that there is not a disruption in benefits as a result of an inheritance that they've received. Or if one parent were to go into a nursing home, the power of attorney needs to say that you can continue to support a dependent child. So very, very important there. It's also important to understand what are your duties and obligations with regards to the child when they're a child, and then also once they become an adult. And there is a different set of responsibilities associated with those. And then how do we maintain public benefits eligibility, and also just providing some support for caregivers. I often say, parenting isn't easy in general. And there are days where even with my twins, I get that caretaker burnout. And so it is a real thing. We understand that. And so trying to find out what resources are available and what types of support are there to keep the caregiver energized becomes also important. All right, so let's start off with public benefits basics. All right, so there are two different systems that I as a planner look at. The first one's going to be benefits based off of financial need, and then we're going to have benefits that are not based on financial need. So a lot of times the first benefit that somebody is going to be eligible for is going to be Supplemental Security Income, called SSI. The individual is basically presumed to have never worked in this situation. And depending on the family's financial situation, they may receive it prior to age 18 if the family income is low enough. If not, then the income will start after attaining the age of 18. So what happens at age 18 is that what's called parental deeming goes away. So it's presumed that as a parent up until age 18, we are responsible for our children. After age 18 is then when you can get available government supports. So that's where SSI comes into play. We also have the Medicaid system, whether or not it's actual waiver services, which are further on down, or the actual just traditional Medicaid healthcare system. You also have your veterans pension benefits. And so I see this a lot more with my elderly clients, but there is actually a benefit if you have disabled children as well, to where your individual aid and attendance pension may actually increase. I see that in very few instances. However, there is not an actual pension benefit for the child themselves after the parent dies under the pension program. This is very different from the compensation program. The pension program is a needs-based program. It is not, I got injured off at war, which is where their compensation benefit is. And as a result, I'm entitled to being paid regardless. The pension is very much, there is a medical need associated with the veteran or surviving spouse, and they will give you some additional money to pay for that care. But it is a means-tested program. The other benefits can also include food stamps, legal aid or utility assistance, or HUD or Section 8 housing. I've already mentioned the waiver services. This is probably the biggest benefit under our state system. So a lot of Hampton Roads residents in general have other sources of income. We have high other sources of insurance. So we have a high military population, and with that comes a high government employee population as well. So we do have great federal benefits that a lot of Hampton Roads residents receive. And so it is very often that my clients say, well, I don't care about traditional Medicaid coverage. Why? Because TRICARE or Blue Cross Blue Shield are covering the things day to day, or medically that my child needs. But it's those waiver programs that become paramount, because that is what will pay for additional care inside the home, often referred to as community-based care. And so those will be how you get your attendance. That's how you will also pay for any additional, you know, therapies that may be needed outside of traditional Medicaid coverage. And then there are going to be state benefits that that various states may have. What I'll tell you is Virginia is very restrictive, and so we do not have a whole bunch of additional state benefits to look at. But if you're moving, or you know, military families in particular, every state will change. It's important to note that out of this list, the one benefit that there is no parental deeming for prior to age 18 are going to be your waivered services. So although your child may not be financially eligible for traditional Medicaid insurance, the waiver is a very individual-based program. And so as long as the child themselves has assets below the $2,000 limit and income below, it's about $2,300 a month threshold, then they will still be eligible for those waiver services. And so there's what's called the ED/CD waiver that we can get turned on right away. But a lot of you may have also heard about the, it used to be the old ID/DD waivers. It's now the My Life, My Community waiver program. And so those are the really coveted waivers that we have a waiting list for. But if you have a child that needs assistance with what we call activities of daily living, you may actually be entitled to waiver services prior to turning on those My Life, My Community waiver services. All right, so what's not financial need? Regular classic Social Security. So this is something that we've paid into for our retirement income. And as a result, you can have $1 billion worth of assets and still be entitled to Social Security. Additionally, Social Security disability is not an asset tested program. SSDI is actually based off of somebody's work record. And so if I were to become disabled, and there is a technical definition that we'll get into, but if I became disabled, I would attach under my SSDI benefit until such time that I was reached my full retirement age. Additionally, if you have a child that is determined to be disabled prior to age 22, they also get to collect under their parents' work record when their parent becomes disabled or retires or dies. And so it's quite often that we see that switch from SSI to SSDI based on one of those qualifying events as a parent, and their income will increase. But even better, if it's something that maybe we don't need a Medicaid waiver program for, then we can have $500,000 worth of assets, continue to collect SSDI from the government, and maybe we just say, okay, well, we don't need classic Medicaid coverage anyways. We'll get into this a little bit more, but if you are receiving $1 in SSI in Virginia, you will automatically also be enrolled in traditional Medicaid coverage. It's a qualifying factor. It's also important to note, let me go back to that prior slide. There is a new range of possibilities for Medicaid coverage in Virginia. So we now have what's called expanded Medicaid coverage, which is strictly income-based. It is not asset-based. And so I work with a lot of people to try and determine what benefits they're receiving and what may be available. And that is one thing that in general, we're not really used to looking at. So I think I touch on that a little bit more later in the presentation. All right, so I briefly touched on SSI. And so essentially, in order to collect SSI, you have to meet the Social Security definition of disability. And if you see on the slide, the definition of disability is that you are no longer able to perform substantial gainful activity as a result of physical or mental impairment that is expected to last at least 12 months or possibly result in death. Now, they do quantify substantial gainful activity. I believe it's about $11.20 per month. And so if you are just unable to earn that amount of money, then you're considered to be disabled. And so I often have to have these discussions with families where just because there's a diagnosis doesn't mean that you're disabled in terms of disability. And so I do have clients who their child is able to matriculate with a regular or even advanced high school diploma. And even better, then they end up going off to college. In those situations, it is very hard to prove disability because they have been able to matriculate through a regular or even more advanced educational program. And so the presumption is that they should be able to work as well. There are more and more employment opportunities for people with diagnoses. And so as a result, it's also helped employment. However, the downside to that is it has decreased the ability to get a disability determination just because you have a diagnosis. In order to collect SSI, it is important that the individual cannot have more than $2,000 worth of assets. And there is an income test. And so we're going to talk about that more in depth because it's a little bit more complicated. It's also important to know that SSI is intended to pay for food and shelter, nothing else. And so there is what's called an in-kind support and maintenance rule, and we're going to talk about this a little bit more. And the basic premise of that rule is that this is for food and shelter. And if you can get it elsewhere, you don't need your full SSI amount. And then once again, I've already discussed this, but a parent's income is going to be deemed to a child under the age of 18. And so a lot of my clients, their children will not be eligible for SSI until they actually obtain age 18, unless there's some kind of issue with the family's change in income situation. All right, so this is where we often see a reduction in the full SSI amount. So currently, SSI amount is $783 per month. In the event that the child is not covering their share of food and shelter related expenses inside the home, they will impose what's called an in-kind support and maintenance rule. Remember, SSI is for food and shelter. And so what they say is if you can get it elsewhere, you don't need the full benefit amount. So what they do, and it's depending on the family dynamics, and I'm not going to get into all of that, but you will either see a 1/3 reduction or you'll see a third plus $20 reduction. And so a lot of times when people come in, this is the reason why I'm seeing a reduction. It's because they are not charging their child rent. It also could be that the SSI amount is not the full amount to cover the child's living expenditures. And then we get to look at various tools such as an ABLE account. And we get into very detailed examples of that. It's also important to understand that unearned income will cause a dollar for dollar reduction. So if they have some sort of annuity, which I definitely see happen for like maybe they had a personal injury settlement or something like that, well then every dollar coming out is treated as income that will then offset SSI. Additionally then, if you have earned income, it will actually be 50 cents on the dollar reduction. Now it's important to understand that the first $20 of unearned income is actually not counted. So if it's just like a random $20 that grandma's giving, it's not a big deal. If it's $100 that grandma's giving, well then what you're going to see is that's not earned income. $20 is ignored, and so $80 will be reduced. There'll be an $80 reduction in the SSI amount, and that's supposed to be reported. Of course, it doesn't always happen. In unearned income or an earned income situation, what happens is they disregard the first $65. And so if they earned $100, what would happen is that the first $65 would be ignored. So what is that, $35? And then you take half of that, and that's what the SSI reduction would actually be. I'm not good at math in my head, and I did not pre-plan for calculations. So hopefully you guys can calculate that. In the event that there is a total, you will lose benefits entirely under SSI if you went over $2,000 in a given month, and that's by a penny. They don't care how much over it is. That is the hard and fast rule. And so this also is sometimes where I have to get involved and clean things up. And I think I said 1120 earlier, but gross earnings over 1260 a month is what it's been increased to. Sorry, I don't remember. I'm not a numbers person. I pull it up every time. But so gross earnings over 1260 a month is actually going to result in a total loss as well. All right, so what are resources? So whenever I talk about the $2,000 limit, what does that mean? It's basically anything that can be converted to cash. And so if you're over $2,000 on the first day of the calendar month is what they're looking at. They presume that income's going to come in, so they're going to offset that out, give you time to spend it down. But at the first of the month is what they're looking at. And so it doesn't matter if, let's say the last day of the month, it's $2,050. That rolls over at the first period, at the first second of the first day of the next month, you're going to be over resources for Social Security for the entire month. you know, subtract out the income, obviously, if you get paid on the first day of the month. So that's important to understand. There are some exceptions though. And so you can own a home and still collect SSI. You can have one car. They do not look at tangible personal property. So the computers, the beds, those types of things that are inside the home. You can have a prepaid burial. Some life insurance policies, such as a group life policy, it doesn't have a cash value to it. It only has a death value to it. And as a result, that's not going to be counted. And then we do have these ABLE accounts. We also have special needs trusts that we'll talk about a little bit more. It's important to understand that inheritances is what causes the biggest problem in SSI for me. And that's because they've received it outright. It is vested down to them. It is their money. And as a result, it throws them over that $2,000 asset requirement. And so we do a lot of special needs trusts to prevent that disruption of benefits. I will explain why an ABLE account doesn't usually work in those situations and the limited reasons why I do use an ABLE account later on down the road. All right. So what are the other Social Security benefits? I've briefly touched on them. We have retirement benefits. So basically people can start collecting that anywhere between 62 and 70. It's important to understand that if you take it earlier than your full retirement age, there's a penalty associated with that. And if you take it after your retirement age, there's a reward for that. So there could be, you know, everybody's Social Security situation is going to be a little bit different for retirement. And in order to collect retirement benefits, you must have worked at least 40, or you must have at least 40 work credits over all of your years of employment. And so that is the requirement to have any sort of retirement benefits down the road. SSDI, the work requirements are going to vary depending upon age. And so that is something that I go back to the book every single time that we are trying to discuss benefits and what may happen. And then in order to collect Social Security disability, you have to meet that Social Security definition of disability. So unable to maintain substantial gainful employment. And then you have the dependent benefits. So this could be for a spouse or child, and it's based off of a retiree or other person's disability record. And so in order to claim a child benefit, and this is not survivor benefits, but the parent is still alive for a dependent benefit, then the child had to have been disabled prior to age 22. And then basically what they're entitled to is half of the parent benefit. And when the parent dies, they'll actually be entitled to 3/4 of the parent benefit. Now there is a family maximum, and so that's important to understand. Once again, calculations are involved, and so I can only speak in generalities with regard to what happens there. There is also a survivor benefit, and so there are benefits for the spouse and child based on the spouse's or based on that decedent's work record as well. And so very often I do see where a child may have a disability, but they are receiving benefits as a result of their parent's death. What will happen is it's at age 16, then they will actually start the disability determination process so that when they turn 18, there's a smooth transition and that benefit will continue on as based on the disability status at that point in time. All right, so I'm going to give you guys a hypothetical. So let's say that John is receiving his full SSI amount of $783 per month. Joe's father, Joe, retires and he receives $1,400 per month. Remember I said that if John is disabled, and I know that he's disabled because he's receiving SSI, so he already has disability determination, I don't need to worry about that. What's going to happen is John will actually start receiving $700 per month of Social Security based off his dad's work record. But because it doesn't actually hit that full $783 per month, he's actually still going to receive some additional benefits. And so what happens is they treat the $700 from Social Security as unearned income. And so they will reduce the SSI benefit by the $680. So remember, $20 disregard, dollar for dollar reduction for unearned income. So John's actually going to still collect SSI of $103 per month. All right, so then we move on to the Medicaid program. So traditionally, there were two Medicaid programs. You have your CHIPS program, which is for children, or parents with or caretakers with low incomes, pregnant women, medically needy, or if you have certain breast or cervical cancers. Okay, so that was one of the traditional programs. It's strictly income-based. There's no asset test to it. And then you had your traditional, what we called ABD Medicaid, age blind disabled Medicaid. And so aged 65, legally blind, or disabled by definition. As I said, we now have Medicaid expansion, and so we do have a new class in here, which is just a low income based benefit. We do also, under the system, have those waivers. So as I mentioned, these are going to be your ABCD waivers, or we call it the CBC, the community-based care benefit waiver. I can get those turned on pretty quickly as long as it's an individual that actually needs care for activities of daily living. So feeding, bathing, dressing, walking, going to the bathroom, and transferring. And in order to meet the eligibility requirements, you need assistance with at least 3 out of 6. They do not care about the meal prep, medication management. Those are all what's called instrumental activities of daily living. They're really looking at skilled nursing home level of care. And the reason for the waiver is to prevent institutionalization. The coveted waiver under the program are going to be the My Life, My Community waivers that will help pay for above and beyond care inside the home, even if the individual can meet the ADL requirements. This is also how we pay for a lot of supported living arrangements. And so that all falls under the waiver programs. It's important to understand that if you're receiving $1 of SSI, you will also have that disability determination and automatic eligibility for Medicaid coverage. And once again, just like SSI, you have a resource limit of $2,000 under the Medicaid program, under the classic like ABD or waiver programs. As I said, CHIPS and the expanded Medicaid coverage are strictly income-based, and so you can have $1 million worth of assets and just low income and still collect Medicaid. All right, so one of the biggest frustrations that I see with parents or family members of people with disabilities is the low or the long waits for the My Life, My Community waiver programs. And so this is the actual statistics from the Commonwealth of Virginia. And if you look at it, the individuals, you break it down between the children or the CHIPS Medicaid program, the parents and caregivers who enrolled under CHIPS, and then your ABD category. So if you look at it, it's only about slightly over, I think it's around 15% of the actual enrollment in Virginia fall under the ABD category. The vast majority of enrollees are under the CHIPS program. But if you look at total Medicaid dollars spent, the largest portion of Medicaid dollars actually falls for the ABD program. And the reason why is those waiver programs are so expensive. If you've ever had to privately pay for care, right now it's about $25 to $26 per hour. And so the waivers do provide a lot of expensive care. And so that's also why we see the limited number of waiver programs here in Virginia. And so I just always think this is a good visual to show kind of how the Medicaid dollars are being spent and why we have such an issue and a barrier to getting the waiver programs. I'm not saying I agree with it. I'm just saying that's the reason behind it. It's a fiscal policy issue. All right, so this is where we get into the Medicaid expansion issue. And so, like I said, this is kind of outside of the normal classical Medicaid that people are thinking of. And so they realize there is a gap because after age 18 and until aged, so 65, unless you had a disability, there was no Medicaid coverage. So we were seeing a gap in people that are just unable to otherwise qualify for health insurance. So what this does is expanded Medicaid eligibility so long as your income is below 138% of the federal poverty level. Prior to expansion, even if you had no income, if you were between ages 18 and 65 and you didn't actually have a disability determination, you were not eligible for any sort of Medicaid assistance. I mean, there are some exceptions, like if you had a child, so that caretaker program, but in general, we saw a large gap there. So states who have not expanded, we still have that gap. Here, we now have the Medicaid eligibility based on expanded Medicaid coverage. We also have Affordable Care Act. So this is something that every once in a while I do have to look at based off of income issues or family dynamics. And so what happened under the Affordable Care Act was that we eliminated the prohibition of pre-existing condition exclusions. We also provided then advanced tax credits. There's cap on out-of-pocket costs. There's cost-sharing subsidies. So under the marketplace, you can apply for subsidies to help offset those premium payments so that you have quote-unquote affordable care. People who are on the exchange often say it's still not very affordable, but you know, it was one of the options or one of the benefits that are available, even if you're above that 138% federal poverty level, and so you may fall into a gap there. There's 4 levels of coverage, so if you've ever seen or signed up for it, you'll know there's like a platinum level, gold level, bronze level, or silver level. And so the premiums will adjust based off of what you choose, but also the benefits adjust as a result as well. Open enrollment for Affordable Care Act is coming up, so it's from November to February, and there is a special enrollment status if there's a change in your healthcare situation. So if you were employed and lost medical insurance as a result of your lost employment, then you can sign up for care under the exchange, even if it's outside that November to February timeframe. Under the Affordable Care Act, there is no long-term care or waiver services under the program, so that's important to note. And not every state has expanded Medicaid, and the Medicaid expansion does come under the Affordable Care Act. So we just recently did ours, I want to say 2 years ago, it was January 2019, I believe. You know, with 2020, it just feels like everything has been, you know, delayed. And so everything's kind of mushing together between 2019 and 2019, or 2019 and 2020 for me. All right, so the other benefits kind of, you know, these aren't the ones that a lot of my family members are looking to right away, or, you know, a lot of the families that I work with. However, Section 8, it is important to note there is a federal case that went to the First Circuit in the federal court system. It was what's called the DeCambry case. And what it was happening is that people would get personal injury settlements, and because they put it in special needs trust, 100% of the distributions that were being pushed out were counted against them in calculating what their rental payment was. They were saying it was all treated as income. Interestingly enough, if those same individuals, so, you know, obviously if we're using special needs trust, they probably have some other means tested benefits anyways, but had that individual just thrown it into a bank account, only the income that was earning on it would have been counted as income, or if it wasn't earning enough, there's an imputed income rate too. But only that is what went in and factored on what the copay was under the Section 8 program. So a couple organizations I'm a member of, Special Needs Alliance, NALA, they both advocated and said this is discriminatory against people with disabilities. And as a result, it went up through the courts, and this is the case that said that no, it's only the income of the trust to the extent distributed out that you can count. And there's this imputed income rule. So that's just important to know that there is a law that specifically carves out that you cannot discriminate due to a disability in the way that you treat special needs trust. Additionally, with ABLE accounts, there is some guidance that HUD has put out too to say that the intention was to exclude ABLE account assets from the overall asset calculations or in imputed income, stuff like that. And so as a result, they're excluding ABLE accounts as well. Food stamps and legal aid and utility assistance, it's so much more complicated. But like I said, those are kind of the minor looked ones. All right, so what are some pitfalls that I often see whenever I'm working with families? Child support, so that is an income to the child, and so that's important to understand. There's ways that we can get around it. Gift to minors account, so if you have just a traditional account that's opened up for a child, usually it's what's called a Transfer to Minors Act account, and so at a certain age, they are entitled to it. You can't, there's some discrepancy under the law right now because we just upped it upped it to age 25, but there's these 21 accounts. And so at age 21, it becomes their assets. Additionally, because it's for their benefit, if you're looking at it from an asset eligibility standpoint, they say you need to use that money before we're going to give you benefits. 529 education accounts are an issue because they're in the minor's name and there's no exception for them. Unstructured beneficiary designations are a huge problem. And so what I see a lot of times is families will name their children as the beneficiaries on some sort of life insurance policy or 401k, bank account, you name it, whatever it could possibly go to. And so if it goes directly to the child, it has gone invested to the child. So even if we have what we're going to call a third-party special needs trust, understanding we've not gotten into those details yet, but if it bypasses the trust and goes directly to the child, that creates an issue. Disinheritance. So I often say that this is one of the worst plans that you can have, because you're entrusting somebody else to make sure that your child is protected. You know, you may trust your son now, but they may get married to a wife that wants the money for herself, and as a result, now you don't have it for the benefit of the child that you wanted it to be, you know, that you wanted to support. Not using a proper trust, and so there are very specific terms that need to be inside of a special needs trust, and so it's not uncommon for me to say, oh, this isn't actually a real special needs trust. If it says support or maintenance, it is going to be considered a support trust under the federal rules. And so as a result, it's going to be treated as a resource and not a special needs trust. And then just no planning at all. I do have clients who really, I say it's the ostrich effect. You know, just want to dig their head in the sand. I don't want to have to deal with it. But that obviously is just planning to fail in the long run, because these are issues that we do need to address. All right, so what should you consider whenever you're looking at planning? So first and foremost, powers of attorney. So your personal documents, and we'll talk about the individual themselves too. So fundamentally, do you have capacity is the number one question. If you have capacity, then we can do documents for you. And so a power of attorney is really just a grant of authority for somebody else to act on your behalf. So does your power of attorney allow for you to support a dependent child? Does it allow gifts to the dependent child if necessary? Do those have to be outright or in trust? It needs to specifically spell these things out. This is called hot powers. And so as Uniform Power of Attorney Act state, even though we have language that says, and my agent can do anything I otherwise would be entitled to do, had I been able to exercise the authority myself, there under the law, it specifically says that unless certain things are spelled out in the power of attorney, you actually can't do it. And so that's where these very specific provisions kind of come into play, because if I need to do any advanced planning for you later for your child, these are things that I'm looking for in your powers of attorney. A large number of power of attorneys that I see walk through the doors do not provide for these types of things. Additionally, does it allow for the creation of trust? So if you have not yet set up a special needs trust for the benefit of your child, or maybe I need a first party versus a third party, whatever the case may be, do I have the authority to do that under terms of your document, or does your agent have the authority to do it with my assistance, I guess is a better way to phrase that. So that's kind of what I'm looking at from a power of attorney standpoint. Your wills and trust, you know, number one, I do not want to leave an inheritance to that individual outright if they're on means tested benefits. That a sudden influx of cash is going to disrupt their benefits. All assets should be directly flowing into a special needs trust. And we'll talk about first party versus third party and where this becomes an issue. And we also need to look at, you know, some people want to treat all their kids evenly. And so sometimes it becomes a real financial analysis. Who needs more support or who needs more of the money? And so, you know, there are times where I see families where they say, look, 80% of my estate needs to go to my child with the disability because I need to make sure they're taken care of. On the flip side, I also have ones who say, well, they're receiving my SBP under the military program. They're going to receive Social Security disability as well. You know, they're already in a residential living option. And as a result, Medicaid's paying for a lot of their basic needs. So they don't need as much as what their brother's going to need. And so it's really going to be dependent on your family situation. There's no right or wrong answer there. And so oftentimes, like, I do not actually make the recommendation with regards to what that should look like, unless it's like, okay, well, let's sit down and actually crunch this. And I can tell you the pros and cons either way, but ultimately it's your decision to decide how your children should be treated at the end of the day. And then retirement benefits, you know, what retirement benefits do you have and how are they going to be impacted? You'll see that the survivor benefit plan under the military program, I can direct into a special needs trust. The problem is I don't have similar provisions or laws under the civil service program. And so that often can cause a disruption as well. All right, so what are the basic tools that we look at, even for, you know, for you or for your child? We're going to be looking at powers of attorney, advanced directives. In the event that you can't do a power of attorney or advanced directive, we may have to look at a guardianship or conservatorship. We do look at various types of trusts. We also look at the military SBP program child support issues, how do trusts get funded, and making sure that there's some adequate funding there. And if you need additional funding, maybe potential life insurance benefits for that. And then what are the housing options that are available? So are they going to stay inside of your home and receive care inside the home? What does that look like as you're aging? You know, it's often important for, in particular, if your child doesn't do well with change, trying to adjust them to the changes as you are getting older and unable to provide care for them. Because if they're ripped up out of their house or their normal setting, in addition to losing the parent who can't help with that transition piece, that can often lead to a disruption. And so what we as parents never want to think of moving that child out sooner than, you know, before we die, if the plan was to keep them at home. Sometimes just understanding the child themselves and how resistant to the change they're going to be and how can we help them through that becomes important. All right, so what the first thing boils down to is surrogate decision making. Okay, so you have your power of attorney advance directive. There is a presumption of capacity. And so the fundamental concept is once we turn 18, we have capacity. So when your child turns 18, you kind of lose that ability to do whatever it is you need to as a result of them turning age 18. And I often say, you got to step back and look at it. When you turned 18, every single one of us has probably said, you can't tell me what to do. I'm an adult now. Same thing applies to your child. You know, the general public doesn't understand that they have a disability or what their limitations are, and that you should just be able to step in. Instead, either the individual, if they have the capacity, needs to appoint you under a power of attorney and advance directive so that you can make decisions or assist with making decisions, or there's going to be a judicial determination of incapacity, and then the court will appoint somebody to make decisions for the individual. The difference between the two, in a power of attorney situation, there's no accountings, there's no bonding requirements, and there's a representative payee thing under the Social Security Administration, and that may or may not be the same person under the power of attorney. In the guardianship conservatorship context, you will need to account for everything. So the court will say, look, we've appointed somebody and we want to make sure there's some protection in place. So you need to account and show us how you spent the money. You can't just take the money for yourself. And similarly, then they're going to put a bond so that if you do mismanage the ward's money, at that point in time, the surety company will put the money back in and they will pursue litigation against you to recollect that money back. Once again, representative payee. So the difference with any federal benefits is that the federal government is separate and apart from the state. And if you go back to civics, you know, anything not expressly reserved for the federal government is for the states to determine. And so what happens is power of attorney, advance directives, guardianships, conservatorships are state creatures. When you're talking about Social Security, when you're talking about Office of Personnel Management or DFAS, those are all federal programs. And so they say, I don't have to respect the power of attorney or advance directive. I don't have to respect guardianship and conservatorship. We appoint our own individual fiduciary based on our terms. And so sometimes you do have this discrepancy between the two. I already said there's this presumption of capacity for powers of attorney advance directive. And whenever I am assessing capacity, I want to decipher it outside the presence of the family and the person who's going to be appointed in most circumstances. In order to determine whether or not somebody has capacity, I need to make sure that they understand the nature and the consequences of the document. And so they need to understand that they are appointing somebody who will be able to assist in making decisions, and that they make decisions, that the individual may make decisions that are contrary to what they would have wanted to happen, or, you know, potentially stealing money, or, you know, whatever those potential consequences may be. So we talk through those issues to make sure the individuals signing these documents have the required capacity. Without the required capacity, when these are executed, they're actually invalid documents. So I do get a lot of calls saying, I need power of attorney. I just got a call the other day. I need a power of attorney for my wife. She is actually brain dead. So she can't communicate with me. She can't even like blink her eyes at this point in time. And so I said, I apologize, but I cannot get documents. Instead, I'd have to go through a guardianship and conservatorship proceeding. And that's going to take a couple weeks. And he said, well, she doesn't have that long to live anymore. And so I said, you know, the best thing I can tell you right now is, unless she were to wake up from the coma, would be to just spend time with your wife. So at that point in time, it is too late to get documents. She just no longer had the capacity to be able to execute them. And that's probably the clearest example that I can ever give, obviously. And then in the event that there's a gray line or some potential dispute over documents, I will recommend getting a doctor's evaluation. So I am not a physician, I am a lawyer. And so there are times with very advanced dementia or just some sort of cognitive impairment where it's important for me to document my file based off of a doctor who is trained in the assessment of these types of cognitive issues, that yes, this person still understands these documents. All right, so the power of attorney, it's a grant of authority to make financial decisions. It's not medical, it's strictly financial. And it's a written document that appoints an agent. So you can't just say, hey, I'm making this person my power of attorney. It has to be in writing so that people can rely upon it. It does create a fiduciary relationship between the principal and agent. So what that means is that you have duties and you need to abide by the terms of the document which you're acting. Otherwise, you can be sued. It will survive incapacity. So my power of attorney, if I was in a car accident and as a result suffered a traumatic brain injury, no longer have capacity, my power of attorney will stand. And my agent will be able to step in and do what they need to do. And once again, the terms of the document itself will govern authority. And so whenever I was going through, does your power of attorney say these things? It's because I need the document to say those things to do some advanced planning. And there are cases where people don't want those advanced powers, and that's fine too. It's just understanding the ramifications of that. All right, your advanced directive. That is actually a document that will grant authority for medical decisions. So that's over the person themselves. The best practices, create the advanced directive in the state in which you're currently living. And the reason why is medical issues in particular vary so vastly from state to state. So assisted suicide is probably the best example that I can say. You know, if I get an Oregon or Washington advanced directive that talks about assisted suicide or, you know, whatever the case may be, that is not going to be looked at all here in Virginia because we just don't have those laws. An advanced directive consists of two documents kind of built into one. So the first one is your living will. So what this talks about is in the event that you have a terminal condition, persistent vegetative state, and we also put like advanced cognitive impairment, do you want extraordinary life prolonging measures? So do you want the machines actually beating for you or beating your heart for you, breathing for you? And then we take it one step further, that also includes food and hydration. Do you want feeding tubes and IV fluids keeping you alive? And then we have your medical power of attorney. The medical power of attorney actually appoints an agent. That agent makes your medical decisions, and it's effective when you can't make your decisions yourself. So it's important to understand that our health decisions are our health decisions. Even if my spouse disagrees with the fact that I decline, let's say, chemotherapy, as my agent can't supersede what I have decided if I have the ability to make the decision myself. So that's kind of paramount. I just talked to a mother yesterday who said, you know, my son doesn't want to stay in school. I need something that says I keep you in school. And I said, well, you're telling me that your child has capacity. Yes, they have capacity. Well, then we're not going to be able to override whether or not they go to school. Even better yet, we can't force them on the bus. We can't kidnap them and take them to school. And so that's kind of what we see in the advanced directive arena. We often want the advanced directive to include a HIPAA release because we probably want your agent to be able to talk to the doctors, review your medical records so that they can give informed consent and evaluate, you know, kind of what's going on. We actually do a separate HIPAA waiver as well, so that even if you can make your decisions yourself, the individual, the agent can help, you know, get the information that may be needed so that you guys can talk about the decision together. The guardianship and conservatorship. So this is when the individual just is incapacitated. And so there are a lot of kind of legislative changes or a lot of bills that are being produced up at the General Assembly right now that tries to have this hybrid of like a surrogate decision maker that somebody appoints. And the fundamental issues that the elder law bar is having right now is that you're either got capacity or you don't. So if you have capacity, you can choose to have this surrogate decision makers involved. You can have powers of attorney, you can have advanced directives. But if you're incapacitated, there's really no way around it. The individual themselves can't appoint, you know, they don't have the requisite capacity to make their own health or financial decisions to engage in surrogate decision making. And so, you know, we're trying to kind of hash out those details to provide other alternatives for families, but this is where we're at right now. You either have capacity, you don't have capacity. If you have capacity documents, no capacity, then we go through this guardianship conservatorship process. These are restrictive, so I do not take them lightly. I am not an attorney that immediately there's a diagnosis, you're disabled, you got incapacity. And I have had to train some of the judges about that. And so the definition of incapacity is you're unable to meet the essential requirements for health care, safety, or therapeutic needs without the assistance or protection of a guardian, or manage property or financial affairs to provide for your support or the support of legal dependents without assistance or protection of a conservator. And so if you meet that definition, that's then when we can get these people appointed. This does not substitute bad decision making. And so for some of my elderly clients in particular, we see this where the family just doesn't agree with the investment decision somebody's making, and so they immediately want a conservatorship to control that. I have to, basically a doctor has to opine, because the court looks to a medical doctor's evaluation, that this person is incapacitated. Bad decisions alone are not going to define incapacity. So the issue with the mom wanting to control the school situation, once again, aside from how do you get them to school if they just don't want to go, is that doesn't mean he's incapacitated just because you don't agree with the decision. That really is a supported decision-making a factor, and working with him as a power of attorney, those types of things to help explain why school is still a good idea. We do have guardianship of the person. So this is going to be decisions of, you know, where are they going to live? What's the course of medical treatment? Are they going to stay in school, or are they going to just be pulled out? Are they going to go to college? You know, there are some pretty cool special needs programs available. Or are they going to work at all? And then you have your conservatorship, and that's really the financial decision. So I tell people, if you think about the advanced directive and what that covers, that's pretty much the guardianship. If you look at the conservatorship, you're going to be looking more at like the financial power of attorney side. All right, so the other thing then we have are the duties. So as a guardian, you need to actually file an annual report with the Department of Social Services. There are a lot of pending legislative changes to the guardianship duties as well. And one of the things is that you are also supposed to take into consideration the wishes of your ward. And so, for instance, if let's say that I became incapacitated, but everybody knew I did not want to go through chemo, you're supposed to say, okay, well, she didn't want chemo, so we're not going to go through the course of chemo treatment. So it's just a primary example, or a good example. So you have to file this annual report. It has to be pretty detailed. It has to explain kind of, you know, what's the current status, where's the person living, what's the current course of medical treatment, those types of things. So those are pretty easy. People can normally file those without my assistance. The conservator, you're going to have the same fiduciary duties as you do as an agent or power of attorney. You can't just use this money whatever way you want. The terms of the court order are going to dictate what you have authority to do. You will have to file annual accountings with what's called the Commissioner of Accounts. So on the date in which you qualify, you'll have to take an inventory of assets. You know, it's not going to happen that same day because it's going to take you some time to get it. But 4 months after qualification, you'll file an inventory. 6 months after qualification, your first accounting, and then annually thereafter, you will file accountings that show how the money was spent. You have to be able to qualify, and so you're often going to have to post a bond, usually no surety on the guardianship bond, normally surety on the conservatorship bond, but there's also some exceptions to there depending upon how much money is going to be under your control. If you have a felony or a bankruptcy, the judge will have to specifically address those issues and may not appoint you. And so I often run into situations where, you know, it's an only child. However, they're bad at managing their own money, or they went through some event. And although mom probably would have wanted that child to take over the finances because it's really their closest living relative, the court may say, I'm sorry, but because of your bankruptcy, I can't appoint you to manage somebody else's money. Additionally, there may be maybe some domestic violence charges from a prior marriage, and you know, you as mom will understand the circumstances around that and would want that child still appointed because you know it's not going to be lashed out on you. However, the court may say, I'm sorry, but because of this, I can't put you in charge of the person. So it's just important to understand that power of attorney and advance directives are always better defaults. You get to choose what you want. And so I look to those before I ever jump into a conservatorship, and I will try and hash out capacity issues as much as what I can to try and make it happen. But if the capacity is not there, there's nothing that I can do at that point. There are some things that you just may need the court to actually bless and approve before you can do it. All right, so then we come down to what is a trust. So this is a lot of meat and potatoes. All right, so a trust is really just a contract to control property. And trusts are drafted so that they're not countable, or special needs trusts are drafted so that they're not countable for public benefits eligibility. So essentially, I can put $1 million in them, and the federal government is not allowed to look at them for SSI. State government can't look at them for Medicaid purposes. Those are usually the two big ones we care about. The key terms in there, that it's not to support the individual. So earlier I mentioned, if it says support and maintenance, the government essentially says, well, this is support trust. They're designed to support you. We're a payer of last resort. We are not the first alternative. And because this is designed to support you, then guess what? You need to use that money first. So the key phrase that you see in a lot of our trusts is that it's designed to supplement and not support public benefits. All right, so there are a couple different types of special needs trust. You have your self-settled special needs trust, and then you have your third party. And what it boils down to is the assets and how they come into the trust. So what you'll see on the next slide is that the self-settled trust is established with the assets of the individual themselves. So you vested down, and there's going to be much more restrictive provisions built in underneath that type of trust. The third party is where we see gifts and inheritance come through. And so this is basically saying this was mom and dad's money. They had no legal obligation to leave their child anything, because we don't. We can give it to a stranger on the street if we wanted to. And so as a result, the terms of that trust are a little bit less restrictive. In the self-settled arena, we have two major categories. The first one's what's called a D4A trust. Those are standalone documents. And then you have what's called a pooled trust, or a D4C trust, that are managed by a nonprofit organization. Not all pooled special needs trusts are created equal. The one that I use is Commonwealth Community Trust here locally. We're blessed that they're actually in Virginia, but they do have a national presence. They show up at the conferences that I go to. They can handle smaller monies, they can handle bigger monies. And the downside to a pooled trust versus the other one, what I'll tell you is from a practical standpoint, is that the trustees of a D4A trust are a lot more proactive, a lot more, there's a lot more responsibility put on them. The D4C trust, your advocate or the individual has to advocate a lot more to get the distributions. And so it's important to understand that while a D4C trust traditionally should be cheaper to manage, I have found out that there are a lot of special needs trusts out there that are actually charging more than Commonwealth Community Trust is. And so that presents a problem to me a lot of times. And actually, some of those fees are just as much as what it would cost to have a standalone one where there's a lot more advocacy. And so what you're seeing is that not all trustees are even going to be equal under the pooled regime. They're definitely not all equal in any of the regimes, when you're doing standalone documents either. So, we do help navigate that trustee process. All right, so special needs trusts are going to be used primarily when there's means tested benefits. In particular, SSI and Medicaid are probably the two biggest. The Affordable Care Act does create alternatives to first party S&Ts, and so I may not always need them. And so in the first party arena, it has to be by law set up by the individual themselves, a parent, a grandparent, a guardian, or the court. No exceptions. So your best friend Joe cannot set up a first party S&T for you. On the other flip side of that, a third party S&T can be set up by anybody. I already said this, but a first party S&T is funded with the assets of the individual, and this would be an outright inheritance. So this is what I have to use if there's an outright inheritance. So if no planning was done by mom and dad, and it vests down to the individual, I now have to use a first party S&T because it's been vested to the individual. If it goes directly from the will to an already drafted third party special needs trust, then I've avoided that, and it's being funded with assets of a third party. So the beneficiary of a first party special needs trust must be a person with a disability by definition. A third party S&T can actually the person can have a disability or not disability. It's really just the terms of the trust are a little bit more cushiony about, well, in the event they do have a disability, then, you know, we want to make sure that things will be protected. These other things are not normally as important for you guys, but, you know, the trust taxation issues, or what's called a grantor trust. The grantor trustee is important because the beneficiary first party special needs trust cannot be the trustee of that trust. Because they're the grantor, they're the beneficiary. If they have complete control, then it's just like they had it sit in the bank account. In third party special needs trust, the beneficiary cannot be the trustee. However, the person that created the trust, the grantor, actually can still be the trustee. So mom and dad set up the trust for the benefit of son. Mom and dad can serve as the trustee. They're the ones that created the trust in the third party trust arena. Both of these trusts are going to be fully discretionary, meaning that you can distribute as much or as little as what you want. We do not want mandatory payments because that is an automatic. You must push this out. And as a result, it's considered to be, you know, as it's getting pushed out, that's available resources. Inter vivos just means that they're created during lifetime. And so both of them are created during lifetime, or can be created during lifetime. Testamentary means that they're built under your will, so they're not alive until your death. And so the first party S&T is always going to be an inter vivos trust, whereas the third party S&T can be created under the terms of your will, and as a result could be testamentary. The first party special needs trust cannot be revocable under any circumstances. Once again, if you can change those terms, it's like the individual beneficiary has access to the money, and as a result, it's going to be counted. The third party S&T can be revocable because you as the parents are the ones who set that up. And so if you guys want to just get rid of it and give the money back to yourselves, you absolutely can do that. This is probably the biggest, the next 2 points are going to be your biggest issues. In the first party trust arena, they have to be funded prior to age 65. After age 65, unless there's some sort of annuity that was assigned prior to age 65, no more money can go into that, because there is a presumption that age 65, everybody is disabled. And so that rule is really designed to trigger for my elderly clients. They're not sticking $5 million into the trust to get on the Medicaid program. There's also what's called a Medicaid payback. And so I call this, so you can't have your cake and eat it too rule. So if you get $1 million and it's vested down to you as the individual, then I've already showed you kind of the figures, and this is one of the reasons why I show those. The most expensive part of the Medicaid program is having those disability costs. And so there is a requirement that the first person, before a family member gets a dime out of a first party special needs trust, Medicaid gets repaid back for the total amount of medical assistance needed for that individual over the course of their entire lifetime. Now that said, Medicaid doesn't pay 100% of what we otherwise would have paid privately. And so there is some internal cost benefit to it. There's also the intrinsic benefit of the individual got the medical care that they needed, and then also was able to have this money available to pay for those above and beyond care things anyways. So if you look at it from that perspective, I think people understand it. Doesn't mean we like it, but at least we can understand the purpose of that a little bit more. And then in the third party arena, we don't see that Medicaid payback because there's no age limit. I can put money in there at any point in time. All right, so the goal of a self-settled special needs trust is to retain resources. I see these most often in 2 different ways. So personal injury settlements, whenever there is a disability involved, we fund a first party special needs trust quite often. The other thing is that outright inheritance. So $100,000 goes out to that child. I now need to do that first party special needs trust, like I said before. Once again, has to be irrevocable, has to have that Medicaid payback. Third party S&T, loved ones really get to contribute to the trust. I do a lot of standalone ones instead of testamentary ones so that they're existing. And if grandma wants to leave money there, if Uncle Joe wants to leave money there, they can, because I try to promote as much as what I possibly can. That standalone inter vivos trust will also have more privacy than the testamentary ones, which will have to go through probate. And then you get to actually choose the beneficiary to death. There's no Medicaid payback, so you can say, I want to leave 100% of what I have to son 1 who has a disability, but at the death of son 1, I want it to go down to son 2, because it's not that we don't love him, it's just son 1 needed a little bit more support. All right, so what do we look at when we're looking at funding special needs trusts? So number 1, real property. If you have one child who has to stay inside the home, maybe we want that home to go inside the trust for the benefit of that child during their lifetime. Life insurance is a great funding option, particularly whenever there's not a whole lot of liquidity to leave or to be able to provide for the care that you otherwise would have paid for had you still had the income coming in to support the individual. Obviously, if you have any cash or investments, that can go in there. Child support goes into a first party special needs trust, and we'll talk about that in a minute. Any retirement plan, so for TSPs, 401ks, IRAs. There are some major tax issues as a result of what's called the Secure Act from it was December of 2019 that just came out. And so there's actually a benefit to it going to an individual with a disability over somebody who doesn't have a disability, because you can keep what's called a stretch IRA, whereas the individual with a without the disability has to pull out over 10 years. And so if you have $1 million IRA, that would create $100,000 worth of taxable income at least per year to the person without a disability, whereas the person with a disability can pull out of their lifetime, and so it creates much less taxable income. So there are some tax issues to look at, and everybody's situation is going to be completely different when we look at that. And then we have the survivor benefit plan through the military that we often fund into a first party special needs trust. All right, so we're looking at child support. So child support is the unearned income of the child themselves. And so even though it's being paid to mom, it is child's income. And in Virginia, you can actually have child support for a person with disability for the life of that other parent. So there's a concept that basically says that if you have a child with a disability, your support, like your parental duty of support issues, just from a financial perspective, don't just go away. And so we do see that. And then we usually set up a first party special needs trust, because remember, it's their income. It's not mom's income. It's not somebody just giving the money. It is court ordered that this is something that the child is entitled to. So vested down into them, it's their money, goes into a first party special needs trust. I also cannot do this by agreement. The court must say, I direct the money to pay into the special needs trust. So if there's any child support issues, it's important. I don't do divorce work at all, but so I help get the divorce attorneys through what they need to. So if this is an issue that comes up, I work with divorce attorneys all the time. And some of them, what you'll find out, do not know about this either. And so they'll often say, well, it's going to disrupt benefits, so just don't do anything, just forego child support. You do not have to do that because of this. All right, so planning for qualified funds. So this is going to be your 401ks, IRAs. And so the issue here is that you didn't pay tax on it as it's going in. So as it comes out, it is taxable. If you have a Roth IRA, so let's say it's yours, or either inherited, there's no penalty to pull out from it when there's a disability. So if you've saved into there, you can pull out, no penalty. It's also already been taxed as it's been going in, but the growth is what's not taxable in it. And so as a result, you can liquidate, transfer, do whatever you need to. There's not going to be penalties associated with it, and there's no taxes associated with it, which is nice. 401ks and traditional IRAs, on the other hand, are going to be a little bit more complex. So no taxes have been paid on that money as it's going in, 100% taxable as ordinary income as it's coming out. So there's these what are called PLRs, private letter rulings from the Internal Revenue Service, that basically says that inherited IRA can be rolled over into a special needs trust and not be treated as a distribution. So not 100% taxable due to that rollover, because the trust is a grantor trust and being taxed down to that beneficiary's individual tax brackets. We can use the life of the beneficiary as a result of this. There is the Secure Act exception. So remember I said December 2019, that's when all my life got disrupted by Secure Act, but there is still an exception for a special needs trust to receive qualified money and do that stretch IRA that I was talking about. So we can roll over inherited monies into a special needs trust. So logically, we would think we should be able to, understanding it's still a grantor trust, still taxable at my level, should be able to just roll over my money into a first party special needs trust if I needed to as well. We have this random private letter ruling that says, nope, it's going to be treated as a distribution, so 100% taxable. Interestingly enough, they didn't mention the grantor trust provisions at all. So we do have a conflict there. Some financial advisors and some brokerage houses will push the envelope a little bit more than others. And so at any given point in time, one company will do the person's own IRA rollover, another one won't. So sometimes it's really hard to do anything outside the purview. Private letter rulings are actually only for the individual that requested them, so they are not law, they are not precedents. However, we do use them to basically support decisions that we're making. Private letter rulings are very costly, and they take a lot of time to get, so it's not something that we do in all situations. So we can also look at structuring the 401k to, you know, take the tax hit over a few years as opposed to one lump sum if necessary. I did have a client where this is what we had to do in order to prevent the distribution of the, or, you know, taking a major tax hit. So she had been born with cerebral palsy, but her parents pushed her into, and it was a positive pushing. But I guess encouragement is a better word. So she actually was gainfully employed, and they thought they were doing a really good thing because they were max loading her 401ks for her retirement. The problem is that she had developed carpal tunnel, and as a result of the surgeries and everything else, she was no longer able to do all the things that she was able to do for her support previously. And so she was already wheelchair bound, but she was able to transfer and do things that she needed to. But then it got down to the point that because of the carpal tunnel, she could no longer do those things. So then we had to look at Medicaid and liquidation of 401ks and all this fun stuff that we're talking about now, which I know is completely boring because people hate taxes. But it is something that we look at. It's just something important for you guys to understand that that's a whole nother component in planning. It's much more than just documents is what I hope that you're seeing. All right, so then we talk about this Treasury regulation, and there's a separate account rule. And so it's important to understand that you want to designate sub-trusts. And so in the event that you have, let's say you create a revocable living trust and the special needs trust is built up underneath there, the beneficiary, we want the beneficiary of your 401k to say, to the John Doe Special Needs Trust created under the Jane Doe Revocable Living Trust, because then that designates, oh, no, this was separate and apart from the actual Revocable Living Trust. I know that this is supposed to go to a Special Needs Trust, get that stretch IRA. There is a concern over certain beneficiaries. So there are what are called atom bomb beneficiaries. And so a lot of my families do have some charitable interest whenever there's a disability in the family. And so if they're leaving money to charity, that could blow up this whole stretch IRA thing, and they could require that distributions be taken over 5 years. So this is something that we look at very heavily. There are some planning strategies around it, but it is not going to be just your basic run-of-the-mill special needs trust, pump some money into from a 401k as a beneficiary under the separate account rule. It will be, we need to start looking at charitable remainder trusts, things like that. All right, so now we get into ABLE accounts. So when this was going down the pipeline, you know, we thought this would be a really good flexible tool for families. Some organizations have still said that as a result of ABLE accounts, we no longer need special needs trust. I will tell you that as somebody who does special needs planning, that is wholly inaccurate, and I use it for very limited purposes. And it's because of the way this went through. And so the purpose of the ABLE account is to encourage accumulation of private wealth for people with disabilities to pay for disability-related expenses. So that is an actual definition, disability-related expenses. There's a restriction on how old you can be. So you had to have been disabled prior to age 26. For special needs trust, 65 in the self-settled arena, and any age in a third-party special needs trust. So we've eliminated that age 26 with special needs trusts. In order to classify as disabled, you either have to have received SSI or SSDI prior to age 26, or you can file a disability certification. And so there's two ways to establish that disability prior to age 26. I do have some families who just didn't ever apply for benefits for their children, and so we have had to do the disability certification, but there were clear medical records indicating the issues. The contributions to the account be made by anyone, however, it cannot exceed $15,000, which is the current annual gift exclusion amount, so that will change over time. It's adjusted for inflation. So if you have an inheritance of $100,000, it cannot pump into this. If you are making a large gift to fund college education of $20,000, it cannot go into this. It is an aggregate amount contributed, and let's just use this as an example. Let's say that you're leaving $15,000 and your husband wants to leave $15,000. And I'm sorry, but if you as a husband, then it could be your wife too, whatever. Use whatever combination you want. But it's not $30,000, because normally the annual gift exclusion would say $15,000 from each can go in there. No. One account, $15,000 total combined, regardless of who it's coming from. So son can't give 7,500 and you give 15,000. It is $15,000 combined. So that's very, very restrictive. Additionally, there's going to be aggregate account limits that are going to be set by the state. It's important to understand that there is a flat line $100,000 rule for SSI. If the ABLE account goes in excess of $100,000, your SSI benefits will be suspended, and then once the account's back below $100,000, you'll collect your SSI again. Medicaid's going to remain unaffected in that realm. Once again, this has Medicaid payback. So if I have a family saying, by the way, I want to leave my child $100,000. Number one, I can't put it in here. Number two, I can use a third-party special needs trust, avoid a Medicaid payback. For the ABLE account, I have a Medicaid payback. Most of my families still want their third-party special needs trust. From the ABLE account, the distributions from there have to be disability-related expenses. So there's some things that we've been looked at, or that are identified herein as disability-related expenses, but ultimately those have not been fully fleshed out right now. Whereas in my special needs trust, it's anything that otherwise isn't provided by public benefits, so that makes it a little bit more flexible as well. Penalties, if you've contributed too much to the account, there's going to be a penalty. And if you make a withdrawal that is not for a qualified disability-related expense, there can be a penalty associated with it, and regular income tax. These things will grow tax-free like a 529 education account will. So all that interest income that's generating is supposed to be non-tax. And so that is a penalty associated with if it's pulled out for something other than disability-related expenses. It's also important to understand that under some of the law changes that happened subsequent to the initial ABLE account establishment, we can now roll over a 529 education account into an ABLE account. And so, for instance, I had a family where their child he received his diagnosis, I want to say about age 7, but they had already started a college fund whenever he was much younger, and so we were able to roll it over from a 529 education account into that 529 ABLE account. So that's all it is. So by the way, whenever I use the numbers, 529 is a portion under the IRC, the Internal Revenue Code, that exempts out the income tax issues for the traditional 529 education accounts. An ABLE account is a 529A account, and so they built it in underneath those provisions. I will tell you, so I use ABLE accounts for two purposes: an inheritance or some sort of personal injury settlement or something like that, less than $15,000, and I use it to offset in-kind support maintenance. That's pretty much the extent to what I use an ABLE account for, because I just feel like there's much better alternatives out there for the individual. All right, so we do have what's called the Disabled Military Child Protection Act. This becomes very important for a lot of my families. And so when a service member is retiring, they can elect the survivor's benefit plan for spouse and dependent child. Old law was that you had to name a person. And since a trust was not a person, you could not name a special needs trust. You had to name the child themselves. The benefit is up to 55% of that the service member's retirement benefit. So it can be pretty significant for families and a way to support your kid at death. And so we can now assign the SBP to a first-party special needs trust so that we're not receiving too much income and disrupting other benefits. So that becomes super important because the waiver benefits do have an income limit threshold to them. The cost, so just so you know, the election for a spouse is about a 6.5 reduction of the retiree's benefit. For the child, it's only about $20 a month. So it is a very small cost to be able to provide several thousand worth of dollars benefit to a child that will be unable to support themselves. In the event you did not make an election to have the SBP because of that old law that existed, we can use a DD form 149 to say that, at the time the election was made, it was because of this. Now, I don't know when they're going to stop accepting that as an excuse, but it is important to know that getting that cleaned up sooner rather than later is important. And then I have had some service members say I was just not even told that this was a possibility. And so I've been able to use that as well. Now, it's important to note that this is a military benefit. This is not a civil service benefit. While there is a retirement benefit for dependent children, and they use the definition dependent children as opposed to disabled children, which has a whole other set of complications to itself. But the civil service similarly still defines it as person, and I cannot assign the benefit to a special needs trust, so I still run into those issues. It is something that the advocacy groups that I'm a part of is aware of. We're trying to get changed. It's just slow moving through Congress, as one can expect. All right, so I'm going to give a hypothetical to try and round all of this so that you can understand kind of what we see as planners. All right, so I'm going to say we didn't do any planning for Sally. So Sally's working part-time. She is receiving SSI, by the way, so $783 max amount is what we're looking at. She earns $300 a month part-time employment, so earned income. $65 disregard, so it's $235. We're going to divide that by 2, so they're going to reduce her SSI by $117.50. So her benefit now is $665.50. Sally lives at home with her mom, and her mom doesn't charge rent. Sally's benefit is reduced by $261, and it's 1/3 of the max benefit of $783, not 1/3 of that reduced benefit. So her benefit is now, after the earned income benefit, reduced by $404 down to $404.50 per month. Theoretically, we're going to have the same reduction even if they were charging her rent, but it wasn't sufficient to cover her portion of everything. All right. So now Sally also is getting child support payments because dad, is paying those outright to her of $200 per month. That's her unearned income. So now we have an additional reduction of $180 per month. Remember, $20 for disregard, a dollar for dollar reduction. So now her SSI benefit has been reduced to $224.50. And oh, by the way, the dad has this, I'm going to say, it's funny because every time I see this slide, I know that this is here, and I'm like, what was that problem again? So let's say that she was living at home with a guardian who wasn't charging her rent. She didn't live with her dad. Dad's paying child support. Mom was receiving SBP, because that makes a little bit better sense. But anyway, she's receiving these SBP benefits of $250 per month. We already have one $20 disregard for unearned income, so we don't get a second one. Now we're reduced dollar for dollar for that $250 a month. Sally receives no SSI. Also, there's a problem because she now has lost her traditional Medicaid coverage, or the automatic eligibility. Now expanded Medicaid coverage, waiver benefits. She still may have some eligibility there, but it's just kind of in theory, if all we're looking at is traditional Medicaid coverage, then there could be some sort of problem. All right, so what's the solution look like here? So Sally's living at home with her mom or guardian, because I just fixed it on the last slide, who's charging her rent. Mom is using a third-party special needs trust to move that rent. She really had no desire to ever charge her child rent. And so basically mom collects the rent. Mom's going to move in a third-party special needs trust as like a savings account for the child. If the income is not sufficient to pay the pro rata share, then we can use a special needs trust that was set up for the individual, or an ABLE account outright. So S&T can pay to ABLE account, or mom puts money directly into an ABLE account, and then you use the ABLE account to pay the difference that Sally can't pay. And then once it hits mom's account, mom can move to a third-party special needs trust save up, because we had no desire to charge our child rent. And all right, no reduction in benefits. We're still getting paid SSI of $783 per month because they are paying from an ABLE account. And it's important to note, special needs trust cannot pay outright to mom directly because it's an entity providing support. The ABLE account, however, is in the child's name, or in Sally's name. So as a result, it is her money, and so it's not a receipt from somebody else, regardless of who funds it. And so there's some interesting exceptions built under Social Security Administration's policy that exempts that out. So anyways, we still have our $783 a month, great. All right, so there's child support payments that were being received of $200 a month going in a special needs trust. Once again, no reduction because it's going in a special needs trust and it's an exemption. The self-settled special needs trust is also receiving that SBP of $250 a month. no reduction because, oh, by the way, it's an exception and benefit is still $783 a month. Now, the only time we're going to see the reduction is going to be that earned income of $300 per month. That's going to be reduced by the $117.50 that we calculated before. So instead of getting $783 a month, she's going to be receiving $665.50 from SSI, plus her $300 a month of earned income. So instead of just being capped out at $783 per month, she's actually able to make $965.50 per month as a result of her earnings. So hopefully that ties it together. I know I run through it fast, but it's just to try and present some sort of hypothetical situation so you can see that, yes, these things do impact the ability to maximize benefits. I do sometimes have families says, well, I don't care that they're getting the 1/3 reduction. I don't want to go through the hoopla. And while it may not be important during your lifetime, the one thing that I stress is it can be important whenever you're no longer here. And so having that plan in place and having a system set up to maximize benefits during your lifetime becomes important for long-term success for the individual. All right, then we're going to look at housing options. So independent living with support from a Medicaid waiver, you know, the family could inherit a residence. Hope House Foundation is, I used to sit on their board of directors, and that's kind of like, you know, a lot of people know about group homes, which are covered by a Medicaid waiver. Hope House actually sets you up with your own apartment or maybe apartment with one other individual, and they provide the supports that you need inside your apartment. And so it's not a group home situation where everybody's under the same roof. They all have their separate bedrooms, but other common areas. Instead, it's more of that independent living dynamic. Or they could actually be living with a family member. Either way, the waiver provides for those supports. Group home covered by waiver. Everybody has their own room, common areas. We could be looking at Section 8 housing if necessary. The wait list for those are super long. It could be an assisted living facility because there is some contributions under certain waivers, not all of them, or we could be looking at nursing home placement and really advanced care. So thinking through those options and what you want for your child becomes important. All right, so I know that that was a lot for you today. Once again, I apologize about Sunday and my inability to access the internet. I don't know what was going on. We just recently got Cox out there. We had satellite internet prior to, so that would have been even worse, but I just wasn't planning for the internet to go down, so I greatly apologize for that. If you have any questions, feel free to reach out to me at the firm. My contact information was on the first slide, and I know that Fabi knows how to get a hold of me as well, and I can be available to try and set up maybe like a phone thing, or maybe even Fabi can compile a list of questions people have so that I'm not repeating myself. And I can do another kind of pre-recorded, like these are the answers to the questions you guys had. So once again, I just apologize. That's not normally how I operate. It was just taking me 45 minutes to get back to the office whenever I didn't realize until kind of right before, and it kind of threw me for a loop that day. It was a pleasure getting to speak to you guys today, and I look forward to meeting with some of you.